We got you. Let's get this started. I know, Saul, you sent me something, which is great. I'm going to be looking for it. I know John Reilly sent me something. I want to go over what we're going to go over and then kick it off to both of you. It's been about 4 weeks since we did this. We had to skip last one. So sorry about that, but I know over 400 of you registered for this. We've got about 100 or so of you on here. Uh, John Reilly, which you see joining us from Hawaii, and Saul Klein. He's joining us from San Diego. I'm in Ventura County, California. Here's what John outlined for us today. Now, we may not get through all 6 things, but here's the intent. Number one, Rex versus Zillow. Number two, three-way agreement cases. Number three, the top agent network. That's the one I'm curious about, guys. I don't have enough information on that one. You guys do. Number four, the DOJ versus NAR. Number five, Homie. And number six, Nasalik versus MLS Pin. And John, I can't stop smiling, man. Those birds, I love them. I'm like,
oh, wait a minute.
This
You
is
can,
awesome.
you can hear the minor birds outside my window?
It's crazy and amazing at the same time. I'm like, I want to be there, John. All right. Well, where do we?
It's actually a recording just to make you feel jealous.
Got it. It's perfect. Great AI.
Hey,
Great.
I've got to sleep with that going all the time. This is out of my bedroom.
That's crazy. Everyone, let us know what city and state or country you're joining us from. Guys, where do we start with the first one here? Rex, which is Real Estate Exchange versus Zillow. Where do we start with that?
Well, so before we do, and then I'll let John jump in, is there's all this litigation going on. And so we believe that as a real estate professional, we should know about this in case your clients hear about it, in case somebody asks you a question. The more you know, we always say knowledge is power, right? Alvin Toffler. So it's important, even if you don't pick up all of the nuance of what we talk about. The fact is, Tristan, you publish it. We're here all the time. We come back just about every other week to talk about this. Sometimes there are changes, sometimes there aren't. Sometimes there's a new way to look at things. And so this is about information around this litigation, lots of litigation that could have a major effect on the way real estate is bought and sold moving into the future. So we think it's important for everybody, and thanks everybody for jumping in and being patient enough to listen to us.
Very true. Good. Well put, Saul. Well put. And for those of you that are joining for the first time, John Reilly is a recovering attorney, as he likes to call it.
Thank you.
And so he has a lot of knowledge in the legal world. This is why we love him. He breaks down the complicated for us. And Saul Klein, he's currently the CEO of the San Diego MLS. But John and Saul have been going back for a very long time and have helped our community, real estate in general, a lot. So they are what I like to call the sages and the oracles of our world. And I'm here just bringing them together for you. I have questions for them. So when it comes to Rex versus Zillow, why is it important right now?
Well, I think it is addressing some things about the clear cooperation policy. So that's where it has some relevance. But also, the NAR has rules, right, for the MLS, and some are optional and some are mandatory. And they are now interpreting some of the optional ones based on actual practice to be mandatory and imposing fines for it. And I know Saul's been involved from the very beginning with the issue of the segregation rule. So Saul, when we were talking, you shed some light to me on some of the background of why they even had the non-commingling rule.
Yeah, so interesting to me, there is a case, Rex, Real Estate Exchange, is suing Zillow. And suing Zillow over the way Zillow has on its website separated MLS listings from non-MLS listings. And the question came up, a while back. Well, why do they separate them? Because Rex is saying, we don't want you, Zillow, to separate the listings. And Zillow is saying, hey, it's not our fault. We took the listings from the MLSs, and that was one of the rules that some of these MLSs are saying that we need to follow. And so we're just following the rules, and we don't think you should have a case against us. And Rex sued NAR and sued Zillow, didn't sue MLSs. And it's around this putting the MLS listings separate from other brokers' listings or even FSBOs. So how come there was this rule that's now optional? How come this rule is even there that says you should separate MLS listings from other sources of listings? And so, I come down on the side of Zillow. I never thought of myself as defending Zillow, someone who would defend Zillow, but I have to, because I think that they're doing what you would do in a case like this, in a situation like this. So this goes back to 1995. And in 1995, listings were scattered across the internet. And you had to go to multiple sites to find only a few listings. And the idea came up that if realtors put all their listings in one place, realtor.com, if they put all the listings in one, and all kinds of stuff, people are going to pop up, NAR sold us out, that's a whole nother story. What happened was that realtor.com, the people from NAR, I was one of them. I was the one, actually, that it went out to MLSs and said, look at this new thing called the World Wide Web that people can access. And what a great place to showcase your properties for sale. But brokers were afraid of something called public access to MLS because the DOJ and the FTC, even back then, were pressuring the industry. They were kind of saying, MLS is a public utility. Everybody should have access. You shouldn't have to join everybody should have access. And brokers, part of the value proposition of a broker was you had to go to a broker to find out what was for sale because the broker had access to the multiple listing service. And so to take those listings from multiple listing service or from a broker and put them on this public web, on the World Wide Web, that was actually a threat to brokers. And so brokers weren't open to wanting to do this. And so I went out to multiple listing services across the country, and I had to make this case for why this was the new thing. This is where you were going to advertise your properties for sale. And if we could get enough MLSs participating, we would create something called a critical mass. Instead of having to go to this website and this website and this website, you go to one website where there's enough properties to keep people satisfied, a critical mass. And to get MLSs to agree to provide their listings to help us create a critical mass, we had to make some promises to the MLSs. And one of the promises that we made was we won't allow FSBOs to go up here on this critical mass, because if we had this critical mass and FSBOs could just go put their listings there, that would be a disincentive to listing with a broker. And if we were trying to convince brokers to put their listings on the internet, if we put them on the internet and that gave FSBOs an incentive not to use a broker, no broker would agree to put their listings on the internet at the time. And so we promised, and I sent you one of the original slides. It's all digital, but the value proposition that I created at the time to say, don't worry, we're not going to commingle. We're not going to mix your listings, MLSs, with FSBO listings. Now, over time, what happened is new business models popped up, and new business models that didn't include putting the listings in the MLS. And so should those new business models benefit from the critical mass that's created from MLS listings, which we know are MLS is the single source of truth, the best listing data. And if consumers know they can go to one site and that's where they can get all of the listings from all of the MLSs, then the brokers that are the people that don't want to participate in MLS, they're going to get to use the advantage of the critical mass that agents and brokers pay for by belonging to the MLS. So that's why there's this no commingling rule. And so the MLS and the NAR in their NAR handbook, and remember, all these MLSs are individual corporate entities. NAR doesn't own an MLS, but has a rule book that if you follow the rules, you get certain benefits as an MLS. And one of the rules that's optional is don't mix the non-MLS listings with the MLS listings because there could be a difference. People know what to expect from an MLS, and these other listings, maybe we're not so sure what to expect. So there's litigation because Rex feels they're not being treated fairly. Did I cover that, John?
He's muted. John, you're muted, buddy.
Or he did that so that he'd mute the birds.
Yeah, you didn't like the birds. Hey
love the
guys,
birds.
shut up back there. Yeah, why don't we jump to the top agent network versus NAR case? That's been going on for a long time.
Yep.
And the original trial of it, the judge dismissed the case and dismissed it with prejudice, meaning you couldn't give it again. But when the appellate court got in there and said, no, it's not going to work, they really covered an important issue. So they did away with that, and the appellate court opened it up again. And then just recently, the newsy thing is both the NAR and the TAN, top agent guys, they reached their own agreement to dismiss the case, but without prejudice. And I think you see this in some of the other litigation that we're having, in the U.S. But so they opened it up, and they said the original court went to the wrong marketplace. They said this wasn't an antitrust violation against the buyers and sellers out there. That was downstream. The upstream, what they call the upstream market, is where people can put their listings, the listing marketplace. And basically the NAR had set up barriers for new entries to come in there. And they are saying that there is validity in the claim and that they want to have adjudicated. But what they did in the dismissal, both parties said, NAR is really involved with this policy, right? And there's pros and there's cons about it in the industry. So why don't we cool the lawsuit for a little bit and see what the industry does with the clear cooperation policy? And if the DOJ doesn't like it, well, they'll probably come in, or the parties will then resume their lawsuit. So they have put a delay, a pause in the case, and it's all centered around the resolution of the clear cooperation policy.
So this is about private listing networks. Private listing networks. And so the questions that come to my mind are, is a private listing network in the best interest of the consumer, or is it not in the best interest of the consumer? And I'm totally myself against private listing networks. But so we've got these private listing networks, and they would take listings and not put them into the MLS, which is, that's a whole nother story. And is it right that you have these private listing networks that are able to put their listings in one place and not put them in the MLS? And then this kind of ties to, as John said, clear cooperation, where you take a listing, you got to put it in the MLS within a certain period of time. And the DOJ has an interest in consumers, right? They're interested in making sure that consumers get a fair deal. But what John mentions, upstream and downstream, an interesting point from the DOJ is not only does the DOJ want buyers and sellers of real estate, those types of consumers, to have competition, more models to choose from, but they also think upstream that brokers should have more choice in the marketing tools that they use. And maybe multiple listing services are too monopolistic, and maybe there should be ways that new types of MLSs can come into the marketplace. And so that's this bigger picture around private listing networks. Protect the consumer, but also give brokers more choice.
So I have a question about that. So remember pre-Trump, we were talking about how what happens when when this whole new world changes, right? It's changed. Like I feel like something's crazy is happening almost every day. Less now, right? But the first 21 days were crazy. Now, when we're looking at this, right, and then we tie it to NAR versus the DOJ. Does the DOJ even have time right now for NAR? Like that's how I'm seeing it's like, are we even going to be a blip? Because I feel like the DOJ now has other things than they need to focus on, and we may be kicked down the road a long time. What do you guys think about
Well,
that?
you know, Bondo, who made a statement the other day that they are going to be very active in antitrust enforcement. So she came out publicly with that. Now, what they're going to do as far as implementation goes, I don't know, but she is going to beef up that department.
So here's what I think. I think it's a fool's errand to believe that the DOJ is not going to press what they've been pressing for the last 50 years through many different administrations. As a matter of fact, the big case that is still under investigation that was closed down and opened up originated under the first Trump term. And so the DOJ has an institutional memory. And it goes way beyond, I believe, who's sitting at the head of the executive branch of government. It's these agencies. And again, as John said, Pam Bondi said that antitrust is a big deal. And of course, there are a lot of people that believe that there's antitrust in the Department of Justice believes there's antitrust violations. And somebody mentioned, well, Trump's a real estate guy, and I agree he's a real estate guy, but he's pretty much a commercial real estate guy. And that's a lot different than somebody who's a residential real estate person, right? And from New York. And New York, we used to always say about New York, doesn't even have what we would refer to as, in New York City anyway, a multiple listing service, right?
That's true. That means we might have problems.
So I wouldn't bank on nothing happening. I would be prepared. And that means education. Just stay up to date on this stuff. Figure out as things change how you're going to make the most of the change because you figured it out before anybody else did.
Which is what we're doing right now, guys. So thank you for that, by the way.
You know, another case that's coming right around the corner is the Dosalik versus MLS PIN. In that particular, case, which has been going on a long time, the judge has just set a hearing for April 1st. And that's giving the DOJ a little bit of time to create another statement of interest. They had an original statement of interest. Now they're going to respond to what the MLS PIN's revised plan is. And this is about the third revision of a proposed plan. But basically, MLS PIN is sticking to the belief that the sellers should have the power and the right, if they can, to make offers of compensations in the MLS PIN. So they're coming, right in the face of the DOJ, and we know that there's going to be a pretty hot response with a statement of interest updated by the DOJ. So that's what I see as something important to look at.
Well, John, was the MLS PIN covered in the settlement? Because even if no matter what the DOJ says, you've got all of these MLSs that have agreed to remove offers of compensation.
No, but MLS PIN opted out of. It said, no way, we're going to go, we're going to come up with our own rules, and this is what is going to be fought in, and the hearing is April 1st. So I know the DOJ is busy writing a lot of other things, but they're going to address that one with a memo that's going to be always helpful for us to kind of get a feel for what's the temperature of the DOJ as far as the real estate industry goes.
Well, in MLS PIN, no select MLS PIN, the DOJ pretty much, if you read the statement of interest, they tell you they don't like compensation offered at all
By
from the
anyone.
seller
Yep.
before the transaction, right? So they don't like that at all. And it's interesting that MLS PIN, which is not that followed the NAR rules, but it's not an NAR type of MLS, said we don't want the settlement because now, if in fact the MLS PIN prevails, that doesn't mean everybody else, every other MLS can go back and enter compensation into the MLS because they've already agreed in this settlement to remove offers of compensation. Is that right, John?
Yeah.
All right. So then where does this land? Because you guys, well, we together have called it like right on, like what was going to happen with NAR, what was between the NAR and T's. Now I forgot the case.
Sister?
Yeah, thank you.
Sister.
And then how the DOJ was going to come in last minute, which they did, right? And then the results of that. And then we were also saying, and you can now finally start seeing it, that it wasn't going to really change the way we do business, right? Dramatically. And now we're seeing we were right. It's like, look at the commissions, right? Look at what's happening.
Sure.
And so knowing that between the three of us, we seem to be having a good track record, right? Where does that leave the DOJ with the NAR in the next, let's give it a year, in the next year so we can have some time. What do you guys think?
Well, you got to remember what is the what new information is the NAR having to reveal to the DOJ with those CIDs, those civil investigative demands, those administrative admins that is forcing NAR to reveal a lot of the background as to why some of these exclusionary policies were developed. So there's more meat for the DOJ to digest, and they're collecting it. Although legally, there's a lot of battles with the NAR arguing that they're expanding too far, that it's too broad of a reach for these subpoenas. But they're going to learn some good information, so they could decide based on that new information. The DOJ could take a stronger position with a consent decree, perhaps, and maybe one though that is crafted so that that was what happened in 2020 when there was all the fight was over the interpretation of the consent decree.
Yeah, so I think, Tristan, that there's a number of things that we need to look at. Number one, the DOJ is not going to leave the residential real estate industry alone.
Okay, got it.
Right?
Perfect.
Doesn't matter who it is that's president, they're not going to leave the industry alone.
Now,
Now,
before you go on to the next one, does that mean they won't leave them alone no matter what? It'll just will always be a target as long as we're around, or do they want to get to a certain point and then back off and then maybe later again come back? What's the caveat there?
well, of course, this is a guess, but in my mind, they're going to want to get to a certain point. There are certain issues that are major issues that, if corrected, could actually change the face of organized real estate. And that might be enough temporarily. Now, they're still going to be looking for violations of antitrust, and those people that are guilty, they're going to have to deal with it. But there's some major areas right now. One is the three-way agreement. The three-way agreement is what funds NAR. That's the agreement that says you can't just join one association, you have to join national, state, and local. And the DOJ doesn't necessarily like that arrangement. And that's what keeps NAR funded, because if you were given the choice, you can belong to local or state or national or all three. Most people coming in the industry, if you said, well, here's what it cost you to belong to all three, here's what it cost you to belong to two, here's what it cost you to belong to one, what might you say before you closed a deal? That you want to belong to one and not the other two because you don't yet see the value of the other two, and all of a sudden the state doesn't get funded and the national doesn't get funded. That dramatically changes the efforts, the lobbying efforts of these entities. It really could cripple them financially. And so
Yeah.
the three-way agreement is very important. And then there's this other one, this other issue that has to do with illegal tying. And people should need to be aware, because a lot of people today are saying, I don't want to belong to NAR, but I like my local association. And I don't like any realtor associations, but I have to join because if I don't, I can't access the MLS.
Yeah. I hear
So,
that all the time.
right. So in California, we know since 1976, you don't have to be a realtor. As long as you're licensed, you can access the MLS, you can join the MLS, but a lot of states, that's not the case. We could see some kind of national play, and I think we are going to, by the DOJ to say that's illegal tying. You can't force people to join your club to be
Hmm.
able to access a tool that's required for them to conduct business. And we know in California, Florida, Alabama, and Georgia, you don't have to be a realtor. Now, in California, you don't have to be, and yet most people still are. And I don't know if that's because of the value that they see in belonging to the association, or if they just don't know you don't have to belong to both, right?
Good
But
question.
we'll probably see some change there. And then we're going to see something around CCP, clear cooperation policy.
Now, do you think those are tied together eventually, or do they always stay separate?
I think the three-way agreement is separate from illegal tying from I think they're separate. Now they might all get bunched together
That's
as
what
we
I'm thinking happens because it just becomes more powerful that way. It's like, you know what? Let's just bring them together. Let's get rid of it. And then that would be a problem. That's where I agree with you too, by the way.
Yeah. Somebody says the office makes us belong. Well, the office might make you belong because if you're in a state that if your broker is a realtor, then because of something called the broker dues formula, you either need to be a realtor or your broker has to pay for you, right? So if you're in California, then you don't need to be a realtor to access the MLS. But if your broker's a realtor, either you pay to be a realtor or your broker pays for you. Most brokers, and I remember when I was practicing and I had agents working for me, I was a realtor and I was proud to be a realtor. And so one of the criteria for working for me was you had to join the Association of Realtors, and I wasn't going to pay your fee. If you weren't willing to join, then you needed to go find another broker.
You know, this is where in the Phoenix case, one of the brokers said, as a challenge to the three-way agreement, he basically set up another choice for his agents to basically separate themselves and become have access to MLS choice, which is to give them just a portion of some of the benefits, but not all of them. But they didn't have to become a member of the state or the national. So there's a big challenge going on. I know that the NAR sent out a team to Phoenix to try to talk story with the agents out there about the consequences of it. But
Yeah.
that's another serious one to follow. And by the way, a number of these cases that we've talked about and stuff, we kind of cover in detail in the dataadvocate.com, so that's where a lot of the documentation is
Let
found.
me grab that and put it into, there we go. Put it into the chat, guys. Please go visit that. Let's go over one more and let's make it Homie versus NAR group boycott case. Let's go over that.
Yeah, by the way, this is not a class action suit. This is a class by a particular broker. But what I'm interested in is it looks that there's appearance that maybe the decision of the judge could be based on a per se rule versus the rule of reason. And of course, we found out what happened in the Zitzer-Burnett case when the judge basically set up the standard as a per se, because that's like where it's automatically illegal, and you just go into the damages aspect of it.
So,
Yeah.
John, what's Homie suing about?
Well, the fact that that he's been targeted by the brokerage community because he is using new technology to lower the cost, and thus he has a different range of compensation. You know, like if you're an outside broker, he's getting flack from brokers that say basically, you know, that's a great listing we saw, but I'm not going to show it to anybody because the sharing of the commission amount is below my standard. You know, it's not enough. So they're boycotting him. Now, the group boycotts are a per se illegal type of offense. So that's a Utah case, and I think a lot of people would be interested in following that one.
Yeah, so the whole idea of group boycott is something that when I sold real estate, we always cautioned each other not to talk about other brokers' business models because it could be taken, because it was, I think, in a Maryland case many years ago, is that guy
It
not
was a
offering
criminal
enough
case.
compensation? And
Yeah.
so let's not show his listings. And that it was a group boycott, and that caused a lot of problems for, where was that, John? Was it in Maryland?
You know, it was in Maryland, but you know, it way back when it affected guys like us who were teaching, because if we said anything about broker commission, there are people that would stand up and throw apples at us and kick us. They would leave the room, right?
Well,
So
they
you
were
have to be
taught
very
that.
delicate in what you said about commissions.
Yeah, well, people know that. It was, you were taught that if you were in a conversation where people were talking about commissions or not showing properties because somebody wasn't willing to compensate, that you needed to be noisy about your departure, so that if there was litigation, you don't want to be guilty of an antitrust violation. You don't want to even have to begin to defend yourself. And it's too expensive, and it's best to be cautious, and that's what we always taught.
One question from Nancy. Good question. Can it be considered as steering?
Well, it just sure could be. It's not steering in the fair housing way, but that is one of the complaints, is not showing. As a matter of fact, the DOJ investigated some MLSs to say, are people searching based on commission? And because that definitely would be, in the eyes of the DOJ, steering.
And that used to be in the MLS rules, right? It was permitted to say what the split would be, and the DOJ was okay with it, but then they changed their mind.
No. All right. What should we expect in the next few months, guys? Anything as a surprise? Would anything surprise you?
Not anymore.
John, no, not anymore. Well, John, yeah, that's true. You're so right. How
Yeah,
about you,
I
Saul?
wouldn't be surprised at all. I'm looking for further information about the cases that are currently in play. And I would look for opportunities. If I were listing and selling real estate today, I'd look for opportunities for me to differentiate myself based on some of these changes that are coming down the line.
Oh, you know what I just thought of as well is in my area of contracts and contract law, I think there's going to be quite a change now, and I think managing brokers need to take a hard look at their contracts. They can start with a listing contract and making sure it's got the right disclosures in there, and make sure that it talks about the possibility of there being a listing broker fee, but also maybe some of the money is going to be shared because of offers coming in from buyers asking for that as part of the transaction. So you got to be sharp with your own listing agreement from disclosure. You have to be sharp now that you have written buyer agency agreements. You have to be very clear about how you're going to handle compensation to the buyer agent. You know, is it going to be hourly, flat? Is it going to be a sharing of a percentage of the purchase price? Or is it going to be some new model where it's based on, let's say, the savings that you can bring as an agent to the buyer, and doing some type of calculation around that. So you're going to see new forms of it. But the other contract that's interesting to me is the purchase agreement itself. You know, the listing on both the buyer and the seller side, that can be custom made. The attorneys for the broker can work that up. But everybody seems to use one set purchase agreement. Because if each one of the transactions had their own separate purchase agreement, that would cause havoc to the whole industry. So you're probably going to see some type of a basic contract, but then attached to it would be kind of an addendum or a memorandum of understanding as to, you know, how the compensation is determined for the buyer broker out of the transaction. That's what you're going to see.
Makes sense. And
Attorney full employment.
I don't want to forget one thing. Saul, you sent me this. I wanted to end with this. Tell us about this.
Well, that's the slide I use. Why should I advertise with RIN? RIN was the Realtors Information Network, and it grew into Realtor.com. And so what we told brokers is, let's put our listings together in one spot so we create a critical mass. We leverage our existing dominance because MLS was a dominant database of available properties for sale. And this was the key point, which is part of this Rex conversation. No for sale by owner. Because we don't want for sale by owners to benefit from all of the critical mass created by the MLS, because if they can, they might not list with a broker. So no for sale by owner. And initially on Realtor.com, no addresses, because the brokers, the listing brokers, wanted people to contact the office. So they put it up there for sale, but they didn't want people to be able to do any more research on their own. So no addresses. And then get this, an optional link to the agent. Because not all agents had email.
True.
And an optional link to your homepage, because brokers, so you put your listing up there, you want people to find out more. Now, we don't allow those links in the MLS today, but back then on this public portal that became Realtor.com, we did allow it. And we told people, it was true at the time, brokers and agents can differentiate themselves this way. And we've come a long way, Tristan, since we created this slide in 1995.
Well, man, it feels like I feel like we might go back a little bit there. So we'll see how it goes.
We might.
We'll see how it goes. Saul, John, thank you again. We appreciate it. Great job, John, on the AI birds. Bring them back for the next round, please.
Okay.
It was a joke. See you. Thanks, everybody.
What's AI?
Yeah, you're funny. Yeah. Thanks, guys.
Take care.